I am Rabbi Jessica Zimmerman Graf, the Senior Rabbi at Congregation Sherith Israel, and I am really delighted to be joined today by three incredible long-term congregants and people who have worked to make the world better, more just, and who have continued to help to build Sherith Israel in every way that they make the world a better place and bring great thought and great intention, kavanah, to everything that they do. So I just want to assure everybody, you don't need to be anxious. We will have a hard stop at 5:55. So after you learn from our three judges today, we can apply some of what we're learning today maybe to the vice presidential debate and come to understand what's happening in the world. So by way of introduction, I want to say that this series that we've called From the Front Lines has been an introduction kind of to current events. It started out as specifically a conversation about COVID and what was happening in our world with some of our incredible medical professionals who are in our congregation. And as the larger conversation has continued to change, even during this pandemic time, we have adapted to include the teaching and the ideas, the expertise of some of our local folks in so many different areas working in our world, to change our world. And I feel very fortunate to be in a congregation that has just such extraordinary members who are doing such interesting things out there. So the idea for this From the Front Lines conversation came from Ellen Newman. So shout out to Ellen and Lonnie Zwerin, who came up with ideas about how we might really address the most current, well, at the time it was the most current. It is no longer the most current event out there as the world has continued to spiral in kind of a crazy way in this last week. But with the death of Justice Ruth Bader Ginsburg, certainly the Jewish community and the American public were really moved, kind of rocked by what happened and the timing of her death. And we wanted to take a look at it through the eyes of our local experts in this way. So we don't know what lies ahead. We don't know what's going to be next, but this is a little look into the future, perhaps, of our justice system. I'd like to introduce our three guest experts today, and I'm going to go in reverse alphabetical order since everything else has been forward and I grew up as a Z. I recognize the importance of going alphabetically backwards sometimes. First, Justice Kathryn Werdegar, who is a retired justice of the California Supreme Court. And she is joined by Judge Jeffrey Ross, a San Francisco Superior Court judge, and Justice Stuart Pollak, presiding justice of the California First District Court of Appeal. Did I get everybody's positions right? I hope so. If not, please correct me. I don't know, Stu's saying close maybe. Close enough. Okay. So I want to frame this, and Gordon, maybe you can help spotlight our speakers so we can see people as they're answering the questions would be great. We wanted to look really first to talk about the legacy of Justice Ruth Bader Ginsburg, her contribution to the American justice system, her voice as a woman and as a proud Jew on the Supreme Court has been much discussed, but also remains a very profound, I think, part of her legal contribution and her contribution to our justice system. We know from much that's been written about Justice Ginsburg that she had the words from Torah, tzedek, tzedek, tirdof, on the wall of her office in the Supreme Court, watching the very moving Jewish prayers being said over her casket by a rabbi in the Supreme Court was really extraordinary, I think, in the history of America and certainly the Jewish history of America. And here we are, we find ourselves now living in this time that will be the post-RBG era. So I want to first ask about the personal and professional impact, and Justice Werdegar, if you would begin by speaking to that. How did Justice Ginsburg's legacy, how does it impact you and the work that you did as a pioneering woman on the court for so many years?
Well, thank you, Rabbi. It is a privilege to be part of this group discussing the legacy of Ruth Bader Ginsburg. Although petite, Justice Ginsburg made all women stand a little taller, I think. And as a justice and a judge, for a female judge, she put to rest forever the concept that the appointment of a woman to the bench was as a mere token. She made it quite clear that a woman's voice had to be heard and would prevail. So with her soft voice, she was a very strong presence. She also was an inspiration in other ways. Her workouts, how many have seen the book, the RBG workouts, honestly, and the cute drawings? If she can do it, we can try to do it. And her family dynamic. She gave women permission to ask perhaps a little bit more of their husbands. I only recently learned from my daughter-in-law that there's now the concept of an RBG husband. So males, look out. So she has impacted me and as a judge, and she's impacted women generally.
How did she impact women in law? Please, Justice Pollak.
No, I was just going to tell a little story, which I think well illustrates the change that has taken place and for which she had a great deal to do about it. But Ruth Bader Ginsburg graduated first in her law school class at Columbia. And at that time when she graduated, which happened to be coincidentally the same year I graduated law school, at that time, the person who was first in their class invariably was selected as a Supreme Court law clerk. However, there had never been a woman law clerk at that point in time. And sure enough, she got passed over. She was not selected as a law clerk at that time. Well, fast forward, about 3 or 4 years ago, I think it was, a few years back, all of the law clerks who had clerked her term, which would have been the same term when she would have been there had they selected her, all of the law clerks from the various chambers, who had clerked for the various justices, had a reunion. And the reunion was to be at the Supreme Court building. And we needed to have as a host, so we could meet there, a justice on the Supreme Court. So, of course, who was the host of the law clerks that term, the term of which she would have been there, was none other than Justice Ginsburg. She was a member of the court, and of course, none of the rest of us who were there were. And I think that sort of exemplifies, tells in a story what has happened over the course of her lifetime. And of course, she made an invaluable contribution to that progress.
What an extraordinary story. You know, she was quoted as having said that the difference between a bookkeeper and a Supreme Court justice was one generation, because of course her mother was a bookkeeper. And, it's rather extraordinary that just in that short period of time, having been overlooked despite her brilliance, because of her gender or perhaps because of her religion too, that she was able to then host this group is really quite extraordinary. Great story. How will she be remembered as having changed the legal system? She did so much work to bring justice and equality to people, but what do you think her greatest impact was overall? How will she be remembered in the years to come?
Of whom are you asking?
All three of you. Justice Werdegar, I would love to hear your thoughts on how her legacy will be
Well,
sustained?
she will be remembered as one of the giants in the history of the United States Supreme Court. Apart from all the special aspects of her service, mother, Jewish, and a generation when women didn't do that, put that all aside and just look to her legacy in the law. And she's known for the principles of equality that she articulated as an advocate, that she strategically advanced through choice of special clients and special issues. She was strategic in doing that. So brilliant. And then on the bench, for the jurisprudence that she embraced and articulated in her opinions. One principal legacy is that we no longer can deal in stereotypes of men and women. Through her jurisprudence, she made us realize that the concept of women's roles and men's roles is not fixed in stone. Each gender or sex, if you will, can aspire to do what they are best suited for individually. Women can attend military academies, and men can receive benefits for staying home to care for their children.
Yeah, I think, you know, her contribution, it's in many areas, but it's in the area of anti-discrimination laws. I think that I would say she absolutely stands out. I mean, first and foremost, of course, in terms of gender discrimination, but that was not the limit of it. It includes discrimination on all kinds of bases, ethnicity, physical. One of her lead opinions had to deal with discrimination against or the treatment disabilities, and that area, you know, in terms of, particularly in terms of Jewish values, sympathy and an understanding for everyone, for the stranger, for is where I think she made a very, very pronounced contribution.
Well, in light of the upcoming election, I wanted to just comment on a particular decision that she wrote in the case of Shelby County versus Holder. I'll just give you a moment of background on it. I've picked this opinion for 4 reasons. First, this is the decision that gave rise to the moniker of the notorious RBG. After she issued this dissent, it was then that she got this name, and it was because of the second thing I want to talk about is her voice, the way she articulated her position and concerns in dissent in this case. And because it's a case that is the United States Supreme Court deciding issues with regard to the 1965 Voting Rights Act. And then I'll bring it forward at the end of this conversation to talk about where I think that act may be in coming years by virtue of our Supreme Court. So let me just give you a very quick background. The Voting Rights Act, which was passed in 1965 and signed by President Johnson, was an act to forbid any standard practice or procedure that results in a denial or abridgment of the right of any citizen of the United States to vote on account of race or color. And there were 2 parts of it. I'm going to give you a little bit in the weeds, but I think it'll become important both to understand the power of her voice. And that is, there was a portion of the act, it was called Section 4B, that determined that certain jurisdictions, before they imposed any laws that would restrict voting rights, had to be pre-cleared by the Attorney General or by a court. And what the Supreme Court decided in Shelby County versus Holder, the majority decided that that was no longer necessary. And in this decision, they determined in 2013 that that was not required. And this is Chief Justice Roberts writing for the majority. There is no denying that the conditions that originally justified these measures no longer characterize voting in the covered jurisdictions. So basically what he was saying is that we've gotten to a point now where we no longer have to have extraordinary measures to protect against infringement of voting rights. And the reason I wanted to talk about that is anyone who has read the newspaper or watched television the past few days knows that this is an issue that is very much current, and it is as current today as it was at the time of that decision. So in dissent, she wrote for herself and Justice Breyer, Sotomayor, and Kagan, and said the following: Congress approached the 2006 reauthorization of the Voting Rights Act with great care and seriousness. One would expect more from an opinion striking at the heart of the nation's piece of civil rights legislation. And she read this dissent from the bench, and she continued, the court's opinion can hardly be described as an exemplar of restrained and moderate decision-making. Quite the opposite. Hubris is a fit word for today's demolition of the Voting Rights Act. That was her voice, both in writing and from the bench, in which she was pointing out the tremendous violation of voting rights acts that would come, voting rights that would come from the court's decision. And she goes out to say, and this is the quote that has been publicized quite recently in her obituaries, throwing out preclearance when it has worked and is continuing to work to stop discriminatory changes is like throwing away your umbrella in a rainstorm because you are not getting wet. And we'll talk a little bit more later on about where the Voting Rights Act may be in the Supreme Court in the coming months and years.
So, but where did the nickname come from?
The nickname came from a law student who was so impressed with what she had to say that she took the notorious RBG and gave it to her for her strength of her voice and her role in that decision. And then it followed her on t-shirts and other places after that.
Lots of places after that, yes. I understand she was somewhat in awe of the notorious BIG, for whom she's named and who had quite a different life.
You know, I'd like to say, Jeffrey, it's interesting. You mentioned the strength of her voice, and certainly it was. But in person, she had such a soft voice. But it was a voice, no matter how soft, that was always heard as it deserved to be. But you twice mentioned the strength of her voice, and that does continue on and will.
So I'd like to ask all three of you, how is the court likely to shift to the right? It seems that that's looking inevitable. And what does it mean for our country? In what ways do you think this will significantly impact us? How will Justice Ginsburg's vision be upheld or not as we move to the next step of the court?
Well, I think that all of us are apprehensive and will agree that, yes, it's going to shift to the right. When she was there before her death, the court was 5-4, split along ideological lines. And sometimes Chief Justice Roberts would take the position of a swing vote and on a narrow principle go with the more liberal judges. With her departure, it's an appointment, if it comes to pass, which it seems like it will, by our current president, it's going to be 6-3. So it definitely is going to swing to the right. The only question in my mind is how much restraint the justices will exercise. The court, as we all know, is an unelected body with a life term, and we can explore how that happened and whether it should change. But I think at least the Chief Justice has some sense of his place in history and the respect that should be given to the court. And if they go on a tear, and I'm not saying they won't, but on a tear to overturn everything and enact the principles that the president is hoping for and many of our citizens are hoping for, the legitimacy of the court will be in question. So I'm hoping for restraint.
Justice Werdegar is obviously completely right. To give you a couple of examples, a couple of specifics, areas of concern. I mean, one area that is certainly the right of a woman to an abortion. And to be a little more specific, is tell you what's happened there. And 2000, well, not retracing the whole history of the law in that area, but basically just going back a little bit, there's a case called Casey, which said that restrictions, under Roe v. Wade, restrictions could be placed on the ability to get an abortion so long as they didn't place a, quote, undue burden on that right. Well, in 2016, there was a case from the Supreme Court, Whole Woman's Health. It was a case that arose out of Texas. And Texas had, you may recall from the newspapers, had adopted this provision that would require any doctor performing an abortion to have hospital privileges at certain hospitals, which would in effect mean that there were very few places where it would be possible to get an abortion. And the court in 2016 struck that Texas provision down by a vote of 5-4. And the 5 included Justice Kennedy and Justice Ginsburg. Fast forward now to 2020, a case came before the Supreme Court. It's called the June Medical Services case. This is a case that arose out of Louisiana, I believe. And Louisiana had adopted a provision that essentially was identical to the Texas provision, the Texas restriction. You needed hospital privileges to perform the abortion. Well, that case was decided, it was an interesting case. It was decided by a 4-1-4 vote. The 4 justices who had been on that 2016 Texas case, of course, all found the Louisiana provision to be an undue burden and impermissible. The 5th vote in that case was Justice Roberts. He was the swing vote, but his vote was on a slightly different grounds. He basically agreed that this provision was permissible. He agreed with the dissenters that it was permissible. But the reason he voted with the majority in striking down this Louisiana provision was he thought that as a matter of stare decisis, the court had decided essentially the same issue just a few years before, and he thought that as a matter of avoiding the situation where the court was changing with the election, with the composition of the court, he stuck with the majority and they struck down the Louisiana law. But in terms of what the future holds for us, the other 4 justices on that case who dissented, who are going to permit this limitation to take effect, were, of course, Thomas Alito, Gorsuch, and Kavanaugh. And now, with Ginsburg gone, add the potential replacement who's just been nominated to those 4. Robert's vote isn't going to matter, and there's a concern that that is going to be undone, and that additional restrictions are going to be permissible.
I have to agree with you.
Another example, yeah. I mean, another example is the same-sex marriage case. That was decided 5-4, and with Kennedy and Ginsburg both in the majority. And with those 2 gone and the proposed replacement, you don't need to be a mathematical genius to figure out where that takes you. And lest there be any doubt, there was a case, it was just in the newspaper the other day, some of you may have seen it, it was in the Times. The court turned down a case, they didn't accept the case for review, but 2 justices, Alito and Thomas, wrote a little opinion suggesting that Obergefell, the case that upheld same-sex marriage, should be reconsidered. And now so in terms of what the future may hold, I mean, none of us know, but certainly that's a matter of concern.
May I interrupt you, Stu? Justice Pollak? Can I interrupt you?
Yeah,
As we on the panel know, and many of our listeners might know, there is this concept of stare decisis, which you referenced. What has been decided should remain decided, stability in the law. And a court that wants to change the things you've mentioned, and I'm afraid many others, will have to deal with that concept. And the more they ignore, let lie what has been decided, the less credibility they will have in our society. We know now, unfortunately, how political the court is, and I guess it always has been. Remember Earl Warren? But if they too blatantly undertake to reverse what's gone before, their legitimacy in any respect for them will go by the wayside. I'm throwing that in. I don't know if it will restrain them at all, and I share the concerns that you've expressed.
Yeah. I mean, the other, other broader area that is of concern, of course, is the increasing use of the First Amendment freedom of religion and the right to practice religion as overcoming and negating other rights that other individuals may hold. I mean, the Hobby Lobby case that many of you are probably familiar with, the bakery case, the Masterpiece Cake Shop case involving the baker who refused to sell a birthday cake to a same-sex couple, or not a birthday cake, a wedding cake, excuse me, a wedding cake to a same-sex couple. Those were lost by majorities that remain. So it's not even a question of overturning anything, but it's a matter of expanding and increasing the ability of people who, under claiming their rights to practice their religion, can diminish and negate the rights of others and the anti-discrimination laws in other areas. Let me just finish up by mentioning one case that you want to pay attention to. It's going to be a real bellwether coming up in Philadelphia, which, if you'd like, I could say just a couple words about. It's a very interesting case, and it's going to tell us a lot about where the court is going.
Please.
Yeah. Well, in that case, the city of Philadelphia, the local agency there that referred kids for adoption or for foster parents, I think, as well. In any event, they, under the anti-discrimination law there, the agency refused to refer kids to, in particular, as a Catholic agency that would not place kids with same-sex couples. The local agency held, wait a minute, that's a violation of our anti-discrimination laws, and we're not going to refer kids to agencies that are discriminating against same-sex couples. Well, the claim on the other side, of course, is, wait a minute, you're infringing the religious rights of these organizations that want to discriminate. Well, the Supreme Court, and so far, the Philadelphia has prevailed. I mean, but that issue against the city of Philadelphia, and that is being argued this coming term, and be an interesting case to see where they go. And I think it's going to give us some indication where they're likely to go for some time.
I want to.
I was just gonna
Please, go ahead.
The other area, and the reason I mentioned the Shelby County case is that was a case in which the United States District Court had found the importance of preserving the Voting Rights Act. The Ninth Circuit, which of course is located here in San Francisco, had the same ruling. The court took the case and determined that that provision of the 1965 Voting Rights Act was unconstitutional and unnecessary. The reason I wanted to start with that is the case that the court took on Friday, which will be heard in January, is Brnovich, B-R-N-O-V-I-C-H, versus Democratic National Committee. And that is another case which tests the Voting Rights Act. And it arises in the context of two provisions of Arizona law, which were held to be which were held to violate the Voting Rights Act, because in one case, Arizona said that people could not collect votes and ballots and bring them to the election facilities. Of course, that's an area where people who have disabilities or people who don't have transportation are being assisted. The second one had to do with another provision of Arizona law, which again was an attempt to limit the access to the vote. And in that case, what happened was where people were changing their polling stations and were putting in their ballots from a different polling station, Arizona said those couldn't be counted. So both of these provisions of Arizona law were held to violate the Voting Rights Act. The Ninth Circuit held that was to be the case, and now the US Supreme Court has taken the case. And the point that I want to make is it's pretty clear that they took the case for the same reason they took Shelby County, that there's a high likelihood that they will say that these provisions of Arizona law do not violate the Voting Rights Act, that these should be able to stand. And if that's the case, what we'll see is a number of decisions where states will be able to constrict the rights of people to vote. And we know that that falls most heavily on people of color, people of lower socioeconomic groups, where it's more difficult to get access to the polls. And I bring that up because there's a real concern that we're going to see Bush versus Gore again, where we're going to see the decision in this election going to the United States Supreme Court. And this is a court that already had previously 5 people who thought the Voting Rights Act needed to be curtailed, and very possibly there'll be 6.
I'd like to ask the 3 of you, Justice Werdegar, you touched on the challenge of having life appointments to the Supreme Court, or the reality, let's say, of that. We've also had a couple of questions in the chat about increasing the number of Supreme Court judges. I'd like to hear from the 3 of you what you think about those 2 issues, whether increasing the numbers would be feasible, would be good or bad, and also this question of lifetime appointments and how good that might be for the court.
Well, lifetime appointments is what we have, and we are observing how good it might be for our democracy. I've often reflected that when that provision was put into the Constitution, what do you suppose life expectancy was? Certainly not 85 or 90. I mean, I'm so glad we're all here, but maybe they could anticipate 10, 15, 20 years. Also, so that's become a real issue. And we have several, I think, or a couple of octogenarians on the court, and justices will stay as long as they can. Justice Ginsburg certainly did. She had her reasons. Justice Thomas is of an age, and with all due respect, I think Justice Breyer is of an age. We're all of an age. So lifetime appointments. To change that would require a constitutional amendment, which in the history of our federal constitution is never easily achieved. There's been some talk about that. And there's been recent talk about enacting staggered limited terms. That's down the road. I will just allow my panelists to expound, but on expanding the number of justices on the court. I know that the only thing I know is that Roosevelt threatened to do that when his progressive legislation was being struck down by a very conservative court. This is not the first time we've had deep dissensions and chagrin about our court, that he threatened to expand it. And I think the phrase that we all know is a switch in time saved 9. One of the conservative justices decided, okay, I'll see it the president's way. And so there was no expanding. I've learned that the president whoever it may be, and in this case, if it were Biden, that the president and the Congress can expand the number of justices. I'd be very interested to hear what my fellow jurists say about that. I guess it's workable. They have en-banc panels, like in the Ninth Circuit, that have multiple judges. Intuitively, I'm not in favor of it. And if we start it because we don't like what's happening, then it's a precedent when things go another way. So I'd like to hear what others think about expanding the number of justices.
Well, backing up on the first question in terms of terms for the members of the court, I think a lot of us think that would be a good idea, and I do know that one member of the Supreme Court at this time agrees with that. 20-year terms, for example, would be a good idea. But I think we all also recognize that as a practical matter, the Constitution isn't going to be amended to make that change. So we're probably stuck with, if you will, lifetime appointments, even though 20-year terms or terms of some significant length would probably be a good idea. Again, well, let me just do a little math. There was some talk at one point, before Justice Ginsburg died, of increasing the court to by 2 justices to 11, and that would have shifted the balance between the so-called conservative and liberal justices, or the Democratic appointed and the Republican appointed justices, however you want to look at it. But if now with her death and with a court that will basically be 6-3, to change that balance of power, or challenge what it would take to get a majority, you'd be talking about adding 4 justices to the Supreme Court before that would happen. I mean, it's 6-3 now, and if you wanted to put that 3 so they could have a majority, you need 4 more. As a practical matter, I question whether the country would even be prepared to accept 2 more. Looking back at the what happened during the Roosevelt period and the reactions to court packing at that time, I doubt that it would be feasible for 2. And since 2 wouldn't even accomplish what they're trying to accomplish, I think 4 is definitely out of the question. And I think probably as a result, we're going to wind up with. That's my prediction.
Judge Ross, would you comment on this question?
I think that adding more would just add, or even trying to add more would just add to politicizing the court. I think the damage has already been done with what happened with the nomination of Merrick Garland and how that was not considered. Kavanaugh's nomination process was a disaster in terms of the integrity, I think, and the respect that the court has, and the idea of politicizing it further by trying to pack the court, add justices, I think would just further degrade the reputation of the court. So I don't know what the Senate will try to do. I don't know what the House will try to do, but I hope that we leave the court where it is, and we just hope that, and here's my hope for the future, that whoever the 9th justice is, that she will listen to her colleagues. Hopefully she'll be influenced in part by Justice Sotomayor and Justice Kagan. And we have seen occasionally that justices who join the court and are perceived to come from a particular perspective mellow, change, and adapt, and listen to their colleagues. And I think that our hope is not that we add to the justices, but that we add to the breadth of experience and breadth of thought of the justices so that they can work towards opinions which express a majority view and are in line with precedent.
Thank you. Given the pronoun that you just used, I want to ask all three of you, is there a woman's voice in the law? Is there something that is uniquely a woman's voice in the law or on the bench, would you say, or not?
Well, could I start with that? When I came onto the bench, the Court of Appeal, that would be, I don't know, 40, 35 years ago, there were so few women jurists across the country that scholars were examining this idea, is there a woman's voice? And by that they meant, would a woman jurist be more conciliatory, more mediating, and not as confrontational as the law sometimes is perceived? A lot of time has passed, and now there are many, many women judges on the bench. And I think research has shown that there's not a so-called woman's voice. Justice O'Connor, I think, quoting a Canadian Supreme Court justice, said, a wise old man and a wise old woman will come to the same conclusion. When I was first appointed, I wondered, is that true? But over the years, yes, it is, except for issues, in my experience, that call for particular sensitivity about women and about young girls, and issues that affect women more than men, pay disparity, discrimination, strip searches of teenage girls, where a woman is potentially more sensitive to the reality of the life than a man. Otherwise, most legal issues don't impact gender differences. And when you come to those kinds of issues, I've sat with 4 different women over the years, and any two of us are as like or not alike as any 2 random male-female judges. So I would say, I don't think academics any longer are exploring the idea, is there a woman's voice?
How wonderful to hear that
Yeah.
from you, Justice Werdegar. Thank you for sharing your experience with us. Judge Ross or Justice Pollak, would anything to add to Justice Werdegar's answer from your perspective?
Well, I would just second what Justice Werdegar said. I mean, I've been on the Court of Appeal now for a number of years with several different panels, and mixed half, not literally half, but several women, several men. And I would say there's no perceptible difference that I have been able to discern. Certainly in our discussion of cases, we're as likely to agree or disagree. And that's true whether we're talking about cases of dependency or rape cases or, whatever. I think it's just a non-factor. And some more conservative women judges, conservative men judges, liberal, whatever. I don't think it's a factor today.
Thank you.
I would agree with both of you, but I would turn it around. I think it's always a factor, just as our upbringing is a factor, our race is a factor, our socioeconomic status is a factor, our age is a factor. Every component of our life is a factor that we bring to the bench as judges. And the importance of having a diverse court, as we do here in San Francisco and as we have both in the Court of Appeal and the California Supreme Court, is that we bring all of those life experiences together with the facts of the case and the law as we understand it, and we produce decisions that are reflective of that diverse opinion and that diverse experience. So I think it's one of many things.
That's an excellent statement of the reality. And I remember, I think I'm quoting Justice O'Connor accurately when she said of Justice Thurgood Marshall, how, Stu, maybe you can help me here, Justice Pollak, or one of you, how enlightening and how wonderful it was to hear Justice Thurgood Marshall speak of his experiences and educational to all of them. What you said is absolutely right. It's not just a question of gender.
Thank you all very much. I want to pivot in our remaining 9 minutes because I think people will be really fascinated by something that you brought up, Judge Ross, in our previous conversation that I hadn't really thought about, and I don't know if others have, but I think is significantly impactful. The question of how the judicial system is impacted by the pandemic specifically, and what you're seeing in your courtroom as people are coming for trial. questions about the impact of COVID on the rule of law, how that impacts evictions, safety for court personnel, and how is this pandemic generally impacting our judicial system? I would love you to speak to that.
Well, the court was from the outset of the pandemic deemed to be an essential service. And that meant that here in San Francisco, our doors have been open every day since March 13th, when other doors were closed. However, we had to balance the right of people to access to justice and to the courts with the safety concerns of court personnel and, of course, the safety of the litigants, the lawyers, and jurors. So while the doors have been open and we have been functioning, we have had to adapt. And in the few minutes that we have available, let me give you some examples. Initially, we were not conducting trials, but we knew that we had to do so. And so the first thing that we did here in San Francisco was to say the old system of bringing jurors to court, summoning 200 people, having them come to tell us what hardships they have and what experiences they have that may or may not affect their ability to be jurors just didn't work. So what we did was to implement an online system where last week I summoned 200 jurors. People went online. If they had a hardship, they told me what it was. I granted the hardship. And instead of bringing 200 people to court, we brought no one to court. Those people who didn't have a hardship filled out a questionnaire, and we reviewed the questionnaires. And from that group of questionnaires, we will select a very limited number of people to come to court for trial. And so our criminal court has been functioning in that way. We've had felony trials that have gone forward. The family law section of the court has gone forward. They've been dealing with issues of divorce and adoption and foster care. All of those issues have proceeded. Justice Werdegar?
No, I'm listening to you with great interest.
The Chief Justice has limited certain things from going forward. So for example, because of the pandemic, although there are people who have not paid rent or have otherwise been in violation of the terms of their lease, there are no evictions. And so on the one hand, we've protected tenants from being evicted. On the other hand, there are landlords, some of whom have one unit that they rent, who are not getting rent. And so we've tried as a judicial system, we've tried as a legislative and an executive branch to balance the rights of people on the one hand to have access to justice, and at the same time to protect the health and safety of litigants, lawyers, jurists, and particularly the public coming into the courthouse.
With regard to issues of wearing masks and social distancing, what have you experienced in the courtroom?
We require everybody to wear masks. We require people to use hand sanitizers. The trial that I was about to start, instead of having jurors in a jury box, we were using the entire courtroom, a huge courtroom, so that every juror would be 6 feet from every other juror. Every person in the courtroom would be masked at all times, including the witnesses. And so one of the concerns, of course, is that if you have witnesses testifying on issues of credibility with a mask on, that does limit the ability of the jury to make a determination about credibility. And so people are making choices, and the choices that we have made are protecting people's safety and protecting them from COVID, recognizing that it does, in some respects, limit other people. I'll let Justice Pollak should speak to this, because I know you had a case come before you as to whether masks do or do not violate the constitutional rights of litigants.
Yeah, well, I was just pointing out, in terms of the workload of the courts, I mean, the impact has been on the trial courts and most heavily in cases that jury trial is requested or party is entitled to. The higher courts, the appellate courts, Supreme Court, have all been able to function remotely and reasonably well. I mean, we've been conducting hearings virtually on a different platform now for several months, and that's all working pretty smoothly, I would say. But the whole spectrum of issues and difficulties and balancing safety against people's rights is felt at the trial level. We've had, criminal cases where the trial was postponed because of the pandemic. The court hadn't yet adjusted to handling it, and the defendant said, "Wait a minute, I'm entitled to a trial." This is a defendant who's in custody. Says, "Wait a minute, a certain number of days I'm entitled to a trial, and since I'm not getting that trial within that number of days, I'm entitled to be released." Well, in that particular case, we didn't agree with him. We agreed that some extension was necessary in consideration of the health and safety of everybody involved, the parties, the lawyers, the jurors, everybody else. But that was limited, and it was incumbent on the courts to figure out procedures to get these cases to trial and give people their rights.
Judge Roth, excuse me.
We're accommodating, but I mean, it is a juggling matter, and Jeff Ross is one of the persons who's best able to speak to it, since that's where the difficulties are occurring.
In view of what follows us immediately,
Yes,
what about plexiglass for your witness?
yes, we have erected plexiglass. In addition to the mask, we have plexiglass around the witness, the judge, and the clerk.
But could you have plexiglass with no mask for the witness? Because
Well, the reason we haven't done that is because the advice from public health has been that there are aerosols, and that if you don't have the mask, the aerosols will go up and over the plexiglass and run a risk.
so now we're going to watch that.
Yeah, so we felt it was more important to protect the health of everybody by wearing the masks, and that the shields and the plexiglass would not be sufficient. So that's the way we've struck the balance.
Well, thank you.
Okay.
I want to thank all three of you so much for educating us and helping us to understand some of the complexities of our very complex time. It seems that the way that the judicial system is able to address many of the issues that we're encountering is going to be key for the future of America. And I'm so grateful to the three of you for sharing your expertise, for doing the work that you do, and for being committed, loyal members of Congregation Sherith Israel, helping to build our community over many decades. I guess collectively, we could almost say centuries. Your three families have been very committed to Congregation Sherith Israel. We are so grateful to all of you, and I want to thank everybody who's been on this call learning and thinking about these issues with us. And it is now 5:55 p.m. As I promised, I want to end this call so that we can all participate in the future, hopefully, of democracy in America. Vote, vote, vote. Thank you all very much, and I look forward to seeing you soon. Take care.
Thank you. Bye, everybody. Thank you, Rabbi.
Bye.
Bye.
Thank you. Bye-bye. Bye-bye.